He just reached up her skirt and grabbed her in the butt. Hi there, my name's Leeja. I'm a real life lawyer on a mission to demystify the law and how it affects your everyday life. Today, we're gonna talk about Taylor Swift. That's right, a lot of you have been asking for me to talk about her re-recording of her old albums and why she's doing that, which got me to thinking about other lawsuits and legal troubles Taylor's been in. I'm thinking specifically of the time she sued a guy for $1, and I'd never really looked into that or paid much attention to it, but like, I'm wondering what's going on with that. So I did a little research and I want to talk to you about the many lawsuits and legal troubles of Taylor Swift. First, let me say I'm a lawyer, but I'm not your lawyer. Nothing that I say should be construed as legal advice, and you should always seek the advice of a licensed attorney before making any legal decisions. Okay, so first I'm going to talk about the re-recordings, then we're going to talk about that time she sued that guy for $1. Also, there's this lawsuit involving a theme park in Utah, and then there's like one little bonus lawsuit at the end that I'll throw in, so stick around. Okay, so the fact that Taylor is re-recording her albums is not new. This was announced back in 2019, and it seems like her fans are very on board.
That you're planning on re-recording some of your music. Is that true? Wait a minute. Are you going to do that?
Yeah, that's true, and it's something that I'm very excited about doing.
But they have started now coming out in 2021, so it's kind of resurfaced, and so new questions have arisen as to why she needed to do this. So let's look a little bit into the backstory. So with these re-recordings, she's staying really true, or trying to at least, to the original sound. She's not trying to revamp them or really do anything new with them. She literally is just trying to record the songs to be as true to the original as possible. Although, of course, she's aged more than like a decade for some of these records, so her voice is gonna sound a little different, but she's trying to stay as true as possible. She's even hiring some of the musicians that were on the original album to try to keep it as authentic as possible. And she plans on re-recording and releasing all 6 albums that she made under her old label, Big Machine. This is because Big Machine owned the masters of the original recordings, and they refused to sell them to her. Well, they agreed that if she signed a new contract with them and she put out new albums, she could get the masters for all of her old albums, 1 album per new album she put out. That was kind of the offer they gave her, and she declined. By masters, I mean the final recording of the song that was released on the albums that were then released to the public. Basically, her entire idea is that artists should own their creative works, and she wants to have full ownership and control over the final product of her music. And the only way to get this is to remake the songs, because she signed a contract that promised the masters to Big Machine. So why do these masters even matter? Let's talk about copyright law. So with music, there's a lot of different layers of rights that come when you write a song. I already made a video on the basics of copyrights. I'll link it up here. But music is a little bit different, or a little bit more complicated, I guess. So say you're Taylor Swift, you're 15, you're writing a song in your bedroom with your guitar. You record that song and you put it up on YouTube. You immediately own the rights in that recording and in the song. You own the rights to the lyrics, to the melody, to the guitar part. Pretty much the whole thing immediately becomes your copyrighted material the second that you create it and fix it to a tangible medium. That's what the statute says. In order to have copyrights, you have to fix it to a tangible medium. So if you have a song kind of rattling around in your head, maybe you've started writing it and you've been playing the guitar and figuring out the chord progression and all that, but it's still all in your head, you don't technically own the copyrights to that. It's not until you fix it to a tangible medium, meaning you write it down or you record it, because a recording technically counts as a tangible medium, that's when the copyright's attached. So you make the song, you record it, or you write it down, it becomes your copyrighted material. These rights include the right to publicly perform the work, the right to distribute the work, the right to record the work, the right to make derivative versions of the work. These are all different things that you have the right to do when you own the copyright in something. So in music, there's this concept of licensing, because if you own the copyrights to a song, you can give people permission to use it in different ways. And there are 3 main types of licenses. There is a performance license, which means you've given permission to someone to publicly perform the song. There's a mechanical license, which means that you've given someone permission to distribute the song via CD, via, download, Spotify streaming, or even via like written sheet music. And then there's sync licenses or synchronization licenses, which means you've given someone the right to put the music in a movie or a video of some sort. So if you want to do any of those things, publicly perform it, put it in with a video, or distribute copies of it, you have to get permission from the copyright owner. And this can can be really lucrative. People pay a lot of money for licensing, and you can get a lot of royalty money for those licenses, which is all fine and dandy, but as the copyright owner, you can also sign away those rights, which is frequently what happens with recording artists. They'll sign their rights in their music over to a label, maybe not all of the rights, but at least the like distribution rights for those final masters, the final recordings, meaning that now they no longer own the copyrights. It's the labels that own the rights and then are the ones who do the licensing and make the money. And sure, they'll give the artist the cut, but the ultimate control then is in the hands of the label. And those rights can become really valuable, especially if an artist really makes it big, like in Taylor Swift's case. As an example, Big Machine actually ended up selling the masters of Taylor Swift's music to Ithaca Holdings for $300 million. Ithaca Holdings is owned by Scooter Braun, who manages Justin Bieber and Ariana Grande, and it's someone that Taylor Swift is accused of being a bully. I don't really know what that means, what context that's in, but she doesn't like him. And now he owns the masters to the first 6 of her albums that made her the famous Taylor Swift that she is today. So Swift originally signed her contract with Big Machine back in 2006 when she was still a teen, and it lasted until 2018. And before you question whether or not it's even a valid contract if she was a minor when she signed it, I'm assuming they had pretty strict legal oversight into who they're signing contracts with. If they're a big label, probably wouldn't sign it with a minor without parental consent, but you know, who knows? Even if there was an argument to say that, well, she was a minor when she signed it, so it's not a valid contract, once you continue with a contract after you turn 18, that's saying that you acquiesce to the contract terms, meaning that you can't then contest it years later. So after she turned 18, she stuck with the contract and continued to make albums and perform under the contract, so she couldn't come back and say like, well, I was underage when I signed it, so it's not valid. Anyway, so Big Machine sold those masters and there was nothing that she could do about it. They owned the rights and they sold the rights to Ithaca Holdings. Again, she tried to buy back the masters from Big Machine before this happened, and they offered her the deal of if she signs with them again, they'll give her 1 album of masters for every new album that she makes for them, and she didn't want that because again, the whole point of this is that she wants to own her music, and this was just another means of them having control over her and her signing away another large chunk of her life to them. So then she ended up signing with Universal, and as part of that deal, they gave her all rights to her masters in the future, starting with her album Lover. So she now owns the masters for all of these songs that she's writing going forward. So of course, Ithaca Holdings owns the rights to the masters of those songs. That doesn't necessarily mean that they own all the copyright in the song. So because she's the songwriter, she still owns copyright in that music. She just doesn't have the copyright to that specific recording of the song. So she can now go on and re-record these songs on her own, or with Universal at least, and own the masters in them. And then she'll have full rights to those recorded versions of the song. She's not the first artist to ever do this. There are other bands and artists who have tried to re-record their music in an attempt, again, to gain more control over the final product, to be able to get more money off of it and to be able to control the distribution of it. However, it's often not been very successful for artists because there's just something about like your favorite song, if you've listened to it 500 times, a re-recording, there's going to be something off. There's going to be an extra long pause, there's going to be the sound of the drums is going to be a little different, the singer's voice is going to have aged or sound different. Like, it's really difficult to re-record something completely authentic to the original, and if a fan has listened to that song 500 times, they're gonna hear exactly what's off. For example, the British band Squeeze re-recorded a number of their hits, including their song Tempted, which you've probably heard. Tempted by the fruit of they didn't see a ton of success with that. If you go to their Spotify, the re-recordings are on their discography, but it's not in their top streams even a little bit. And it's because something just sounds a little bit off. Tempted by the fruit of another. And that's something that Taylor Swift might have to face as well with the release of these re-recordings, though it seems as though she's got some pretty diehard fans that are all on board for all of these, and, you know, maybe she'll continue to be successful with them.
I mean, one thing about this album that's really special to me is that it's the first one that I will own of my work.
So that's pretty much why she's doing those re-recordings. It's just so that she can have control over the masters of those songs. So let's turn now to that time that she sued a guy for $1. Major content warning, sexual assault. Great. Great. We love this. Why is every video I do about this? Okay, so listen, there's this guy named David Jackson Mueller who was a radio DJ. And in 2003, he was at a meet and greet with Taylor Swift before one of her shows. And as they were posing for a picture together, he just reached up her skirt and grabbed her in the butt. It was not an accidental graze. It was a full handful grab. She didn't react immediately in the moment, but pretty soon after, she told her mother, she told her people, and they contacted his people, and in the end he ended up losing his job because of this. The guy then had the fucking balls to turn around and sue her for ruining his career, basically for defamation and also for interfering with his contract with his company. So she countersued for assault and battery, and she asked for damages of $1. These are what's called nominal damages. It's basically just a symbolic gesture you can ask the court for. Instead of saying, I want penalty money or I want to be made whole again, like I want, you know, my expenses for therapy or whatever to be covered. It's just like, I want $1 because I just want to be told that he was wrong. I want my day in court. It's not unheard of for nominal damages to be asked for in these cases. The problem is that like most people don't have the funds to bring a lawsuit like this and only make $1 off of it, except for Taylor Swift, which is why she did it. So again, she sued him for assault and battery, and you might be wondering, how did she sue him for battery? Because the typical idea of a battered woman is like someone who's been hit, some sort of more physical abuse. I mean, that didn't happen here. However, the legal definition of battery is just an unwanted touch, an offensive touch by someone else. That's battery. That's all it takes. It doesn't take a hit. It's just like if there was a touch that was not wanted, that is battery. Assault also legally has a different definition than what we think of. So assault we think of as also hitting or some sort of physical touch. Assault does not mean physical touch. Assault under the law is actually an apprehension of an impending physical touch. So if you fear that someone's going to hurt you, like if someone pretends to punch you and you flinch, like that by itself is assault. Any sort of like fear of imminent bodily harm counts as assault. So she sues him for assault and battery. And during 4 years of this court battle, the judge eventually threw out Mueller's cases against Taylor Swift, saying that there was no basis for saying that she ruined his career. And at trial, Taylor Swift testified to what happened to her. There were numerous witnesses that were there and saw it and testified, and there was a photograph. Again, a trigger warning, because like when I first saw this photo, at first I was like, and then I started crying. So there's like something about it that is just, when you first look at it, it seems kind of innocuous, like obviously disgusting, but like, whoa, okay. But then like, when you look at it a little bit longer, you start to realize how just fucked up it is. Like if you look at the look on his face, that shit-eating grin where he knows that he is touching a famous pop star in a way that she does not want, in a sexual way that she did not consent to, and he knows based on history and historical precedent that he will probably get away with it, and he loves that power. And if you look at her face, she's just smiling as though nothing's happening, because that's what we're taught to do, because it's panic, because you don't react immediately in the moment oftentimes. You got fight, flight, or freeze, and a lot of times it's freeze. And a lot of times it's pretend this isn't happening so that we can just get through this and move on. In court, the defense actually had the gall to argue that the fact that she's smiling in that photograph means that it wasn't an offensive touch to her. Can you imagine? Anyway, they didn't buy in. The court found in favor of Taylor Swift for the amount of $1. But it took 4 years and millions of dollars in re-traumatization for Swift to get there. I mean, it was a really symbolic gesture. Like, I'm not a huge fan of Taylor Swift's music. I did not say that at the beginning because I knew some people were gonna click away immediately when I said that. I can respect the work that she put in to bring that lawsuit solely as a symbolic gesture. Because man, that picture, that says it all. So that's the time that Taylor sued a guy for $1. Way to go, Taylor. And now let's move on to the theme park lawsuit. This one is wild to me. So this one's pretty recent. A theme park in Utah called Evermore sued Taylor for her album Evermore that came out in 2020, saying that it was violating its trademark rights that it registered in 2015. So the key issue in trademark law is consumer confusion. Basically, we want to protect consumers from being confused as to the source of the goods that they're buying. We don't want people to be able to just willy-nilly sell counterfeit goods and be able to get away with it. We want to make sure that there aren't marks in the marketplace that are confusing consumers or likely to cause consumer confusion. And the way that we determine whether there might be consumer confusion is in part looking at the similarity between the goods and services that are offered under the marks. So in one case, you have Evermore the theme park, and then on the other hand, you have Evermore the album by Taylor Swift. And somehow they convinced a lawyer to bring a lawsuit claiming that consumers were going to be confused and think that Evermore theme park was in some way affiliated with Taylor Swift. Granted, in the lawsuit they alleged that there was actual confusion, that there were people at the theme park asking like, hey, are you guys affiliated with Taylor Swift? But like under the law, like not really viable. Because like when Taylor's album Evermore came out, were you like, hey, is that affiliated with that theme park in Utah? Because the theme park was there first, so they are the established brand. So the theory would have to be that like consumers confused that Taylor Swift's new album was associated with them. There is this theory in trademark law called reverse confusion, where a newer mark comes along or a newer use that's more famous comes along, and the older mark starts getting confused with being associated with them. Still a stretch. A theme park is not confusable with a Taylor Swift album. And even if there was some overlap, like say the theme park maybe sold like t-shirts or something that said Evermore, and then Taylor Swift started selling t-shirts that also said Evermore, but it's her album, like it's a stretch. However, they didn't end up actually litigating it in court, so we didn't get a determination one way or the other, because Taylor Swift then turned around, or Taylor Swift's people then turned around and sued the theme park, saying that they were playing her album Evermore without getting the proper licenses, which is wild because you'd think that if they were so concerned with being associated with the Taylor Swift album, they wouldn't play that album at their Evermore theme park. So they ended up settling with no money exchanged. They just both sides agreed to drop their respective lawsuits and move on, which was probably the right call in this situation. Okay, so those are the main lawsuits against Taylor Swift, and then there's one bonus lawsuit that's interesting. It was apparently brought by a man named Russell Greer. Frankly, I didn't dig into the details. I just found this self-published book on Amazon with this absolutely iconic cover. The book is called Why I Sued Taylor Swift and How I Became Falsely Known as Frivolous, Litigious, and Crazy. I imagine that this lawsuit was brought pro se, meaning that he didn't have a lawyer, he just filled out the complaint form on the court website and submitted it against Taylor Swift. And I imagine also that the court dismissed it as frivolous and unfounded. It probably didn't go very far. He sued her under a theory of vicarious liability, which I don't fully understand how he got there. Usually that's used by people who sue a company for something that their employee did, saying that the company is vicariously liable because of the employee's actions. I don't know what he was trying to get at here by suing Taylor Swift. I would have to read this book. I don't want to read this book. Maybe you want to read this book, and then you can comment below and let us know what it says. I can't be bothered. I just thought it was funny and wanted to share it with you guys. The back of the book is probably the most iconic part of it. And the back of the book says, Why I Sued Taylor Swift tells the heartwarming story of a disabled songwriter who dreams of writing music for Taylor Swift, only to get stonewalled by her agents. Trying all available options, he soon decides to sue Taylor under the doctrine of vicarious liability in a desperate attempt to get her attention to the unfair situation. Little does this man know that his entire world is about to be turned upside down. But the About the Author section is what really sent me. About the author. Russell Greer lives in Utah and has his paralegal degree. Great. He is an advocate for disabled rights. Awesome. He hopes one day to produce a hit song that he has written. A valiant dream. Greer is also a mac and cheese lover and loves to eat his favorite dish with salsa? Is that something you people are doing out there? That's the most messed up thing about this whole thing, I think. Anyway, it was written in 2017. The reviews on Google are funny. So if you need an entertaining evening activity, maybe check out the link in the description below. Anyway, so that's a brief overview of a few of the legal things that Taylor Swift has gotten involved with over the last few years. I did a similar video on the many lawsuits of Lizzo. I'll link it up here if you're interested. If there are any other celebrities that you'd like me to talk about their lawsuits, I want to do one on Kesha coming up. Go ahead and comment that down below. And let me say a really big thank you to my Patreon supporters. That's right, I launched a Patreon. First, thank you to Brett Piontek and to Anonymous, you know who you are, for being my multi-platinum patrons. Your support means so much to me and you have been so generous and I thank you so much. Also, shout out and welcome to new patrons, Jordan Whiteley, Jason Sachs, and Jennifer Dolo at the Royal Patron level, and Kim Hatcher, Josie, and Daniel Bixler at the VIP patron level. Thank you for your support. It is so appreciated. It makes all of this possible. If I owe you a shout out based on your Patreon tier, don't worry, it's coming. Thanks so much for your views and your support. Let me know in the comments down below if you have any video suggestions. Don't forget to like and subscribe. Thanks so much for watching. Have a good day. Goodbye.